Hello and welcome to the Bored to Sleep podcast. We are here to help distract you from the world outside. We've chosen topics we believe will disengage your brain and help you relax. These episodes have been created by like-minded people to help you drift off to sleep. Therefore, this podcast content should not be taken seriously. If you enjoy this podcast and would like us to make more, be sure to follow, like, and share with your friends. Bored to Sleep, the only podcast where we won't be offended if you fall asleep from boredom. On today's episode, Terms of Service. The source is Wikipedia. Terms of Service, also known as Terms of Use and Terms and Conditions, commonly abbreviated as TOS or TOU and T&C, are the legal agreements between a service provider and a person who wants to use that service. The person must agree to abide by the terms of service in order to use the offered service. Terms of service can also be merely a disclaimer, especially regarding the use of websites. The Terms of Service agreement is mainly used for legal purposes by companies which provide software or services such as web browsers, e-commerce, web search engines, social media, and transport services. A legitimate Terms of Service agreement is legally binding and may be subject to change. Companies can enforce the terms by refusing service. Customers can enforce the terms by filing a lawsuit or arbitration case if they can show that they were actually harmed by a breach of the terms. There is a heightened risk of data going astray during corporate changes, including mergers, divestitures, buyouts, downsizing, etc., when data can be transferred improperly. A Terms of Service agreement typically contains sections pertaining to one or more of the following topics: disambiguation, definition of key words and phrases, user rights and responsibilities, proper or expected usage, definition of misuse, accountability for online actions, behaviour and conduct, privacy policy outlining the use of personal data, payment details such as membership or subscription fees, opt-out policy describing procedure for account termination if available, sometimes contains an arbitration clause detailing the dispute resolution process and limited rights to take a claim to court. Disclaimer: limitation of liability, clarifying the site's legal liability for damages incurred by users. User notification upon modification of terms if offered. Among 102 companies marketing genetic testing to consumers in 2014 for health purposes, 71 had publicly available terms and conditions. 57 of the 71 had disclaimer clauses, including 10 disclaiming liability for injury caused by their own negligence. 51 let the company change terms, including 17 without notice. 34 allowed data disclosure in certain circumstances. 31 require consumers to indemnify the company. 20 promise not to sell data. Among 260 mass-market consumer software license agreements in 2010, 91% disclaimed warranties of merchantability or fitness for purpose or said it was as is. 92% disclaimed consequential, incidental, special, or foreseeable damages. 69% did not warrant the software was free of defects or would work as described in the manual. 55% capped damages at the purchase price or less. 36% said they were not warranting whether it infringed others' intellectual property rights. 32% required arbitration or a specific court. 17% required the customer to pay legal bills of the maker, but not vice versa. Among the terms and conditions of 31 cloud computing services in January to July 2010, operating in England, 27 specified the law to be used, a US state or other country. Most specify that consumers can claim against the company only in a particular city in that jurisdiction, though often the company can claim against the consumer anywhere. Some require claims to be brought within half a year to 2 years. 7 impose arbitration. All forbid illegal and objectionable conduct by the consumer. 13 can amend terms just by posting changes on their own website. A majority disclaim responsibility for confidentiality or backups. Most promise to preserve data only briefly after terminating service. Few promise to delete data thoroughly when the consumer leaves. Some monitor the customer's data to enforce their policies on use. All disclaim warranties and almost all disclaim liability. 24 require the customer to indemnify them. A few indemnify the customer. A few give credits for poor service. 15 promise best efforts and can suspend or stop at any time. The researchers note that rules on location and time limits may be unenforceable for consumers in many jurisdictions with customer protections, that acceptable use policies are rarely enforced, and that quick deletion is dangerous if a court later rules that the termination was wrongful, that local laws often require warranties. Among the 500 most visited websites which use sign-in wrap agreements in September 2018, 70% of agreements had an average sentence length of over 25 words, where 25 or less is needed for consumer readability. Median Flash Reading Ease score was 34, where over 60 is considered readable by consumers. Median Flash Kincaid score was 15 years of school. 498 of 500 had scores higher than the recommended 8th grade. Among 260 mass-market consumer software license agreements, which existed in both 2003 and 2010, median and mean Flash scores were 33 in both years, with a range from 14 to 64 in 2003 and from 15 to 55 in 2010, where over 60 is considered readable by consumers. Median number of words rose from 1,152 to 1,354, with range of 33 to 8,406 in 2003 and from 106 to 13,416 in 2010. Public awareness. A 2013 documentary called Terms and Conditions May Apply publicised issues in terms of service. It was reviewed by 54 professional critics and won the Best Feature Documentary at the Newport Beach Film Festival in 2013 and for Best Documentary at the Sonoma Valley Film Festival in 2013. ClickWrapped.com rates 15 companies on their policies and practices with respect to using users' data, disclosing users' data, amending the terms, closing users' accounts, requiring arbitration, fining users, and clarity. Terms of Service Didn't Read is a group effort that rates 67 companies' terms of service and privacy policies, though its site says the ratings are outdated. It also has browser add-ons that deliver the ratings while at the website of a rated company. Members of the group score each clause in each Terms of Service document, but the same clause can have different scores depending on the context of the services it applies to. The Services tab lists companies in no apparent order, with brief notes about significant clauses from each company. In particular, competitors are not listed together so that users can compare them. A link gives longer notes. It does not typically link to the exact wording from the company. The Topics tab lists topics, like personal data or guarantee, with brief notes from some companies about aspects of the topic. tosback.org, supported by the Electronic Frontier Foundation, lists changes in terms and policies, sequentially, 10 per page, for 160 pages, or nearly 1,600 changes for many online services. There does not seem to be a way to find all the changes for a particular company, or even which companies were tracked in any time period. It links to the Terms of Service Didn't Read, though that typically does not have any evaluation of the most recent changes linked at tosback.org. Terms of service are subject to change and vary from service to service, so several initiatives exist to increase public awareness by clarifying such differences in terms, including availability of previous terms, cancellation or termination of the account and/or service by the user, copyright licensing on user content, data tracking policy and opt-out availability, indemnification or compensation for claims against account or content, notification and feedback prior to changes in terms, notification of government or third-party requests for personal data, notification prior to information transfer in event of merger or acquisition, pseudonym allowance, readability, saved or temporary first and third-party cookies, transparency of security practices, transparency on government or law enforcement requests for content removal. An acceptable use policy, AUP, acceptable usage policy, or fair use policy is a set of rules applied by the owner, creator, or administrator of a network, website, or service that restricts the ways in which the network, website, or system may be used, and sets the guidelines as to how it should be used. AUP documents are written for corporations, businesses, universities, schools, internet service providers, and website owners, often to reduce the potential for legal action that may be taken by a user, and often with little prospect of enforcement. Acceptable use policies are an integral part of the framework of information security policies. It is often common practice to ask new members of an organisation to sign an AUP before they are given access to its information systems. For this reason, an AUP must be concise and clear, while at the same time covering the most important points about what the users are and are not allowed to do with the IT systems of an organisation. It should refer users to the more comprehensive security policy where relevant. It should also, and very notably, define what sanctions will be applied if a user breaks the AUP. Compliance with this policy should, as usual, be measured by regular audits. In some cases, a fair usage policy applied to a service allowing nominally unlimited usage for a fixed fee simply sets a cap on what may be used, intended to allow normal usage but prevent what is considered excessive. For example, users of an unlimited broadband internet service may be subject to suspension, termination, or bandwidth limiting for usage which is continually excessive, unfair, affects other users' enjoyment of the broadband service, or is not consistent with the usage typically expected on a particular access package. The policy is enforced directly without legal proceedings. AUP documents are similar to and often serve the same functions as terms of service document, for example, as used by Google, Gmail, and Yahoo, although not always. In the case of IBM, for instance, the terms of use are about the way in which IBM presents the site, how they interact with visitors of the site, and little to no instruction as to how to use the site. In some cases, AUP documents are named Internet and Email Policy, Internet AUP, Network AUP, or Acceptable IT Use Policy. These documents, even though named differently, largely provide policy statements as to what behaviour is acceptable from users of the local network, Internet, connected via the local network. In general, AUP statements often begin with a statement of the philosophy of the sponsoring organisation and intended reason as to why Internet use is offered to the users of that organisation's network. For example, the sponsoring organisation adopts a philosophy of self-regulation and offers the user connection to the local network and also connection to the Internet, providing that the user accepts the fact that he is going to be personally responsible for the actions taken when connected to the network or the Internet. This may mean that the organisation is not going to provide any warning system should the user contravene the policy, maintaining that it is up to the user to know when his/her actions are in violation of the policy. Often, acceptable use policy documents provide a statement about the use of the network and/or internet and its uses and advantages to the business, school, or other organisation sponsoring connection to the internet. Such a statement may outline the benefit of email systems, ability to gain information from websites, connection with other people through the use of instant messaging, and other similar benefits of various protocols, including the relatively new VoIP services. The most important part of an AUP document is the Code of Conduct, governing the behaviour of a user whilst connected to the internet. The Code of Conduct may include some description of what may be called netiquette, which includes such items of conduct as using appropriate or polite language while online, avoiding illegal activities, ensuring that activities the user may embark on should not disturb or disrupt any other user on the system, and caution not to reveal personal information that could be the cause of identity theft. Most AUP statements outline the consequences of violating the policy. Such violations are met with consequences depending on the relationship of the user with the organisation. Common actions that schools and universities take is to withdraw the service to the violator, and sometimes, if the activities are illegal, the organisation may involve appropriate authorities, such as the local police. Employers will at times withdraw the service from employees, although a more common action is to terminate employment when violations may be hurting the employer in some way or compromise security. Earthlink, an American internet service provider, has a very clear policy relating to the violations of its policy. The company identifies 6 levels of response to violations: issue warnings, written or verbal; suspend the member's newsgroup posting privileges; suspend the member's account; terminate the member's account; bill the member for administrative costs and/or reactivation charges; bring legal action to enjoin violations and/or to collect damages, if any, caused by the violations. Central to most AUP documents is the section detailing unacceptable uses of the network, such as displayed in the University of Chicago's AUP. Unacceptable behaviours may include creation and transmission of offensive, obscene, or indecent documents or images, creation and transmission of material which is designed to cause annoyance, inconvenience, or anxiety, creation of defamatory material, creation and transmission that infringes copyright of another person, transmission of unsolicited commercial or advertising material, and deliberate, unauthorised access to other services, accessible using the connection to the network or internet. Then there is the type of activity that uses the network to waste the time of technical staff to troubleshoot a problem for which the user is the cause, corrupting or destroying other users' data, violating the privacy of other users online, using the network in such a way that denies the service to other users, continuing to use the software or other system for which the user has already been warned about using, and any other misuse of the network, such as introduction of viruses. Disclaimers are often added in order to absolve an organisation from responsibility under specific circumstances. For example, in the case of Anglia Ruskin University, a disclaimer is added, absolving the university for errors or omissions, or for any consequences arising from the use of information contained while on the university website. While disclaimers may be added to any AUP, disclaimers are most often found on AUP documents relating to the use of a website, while those offering a service fail to add such clauses. Particularly when an AUP is written for a college or school setting, AUPs remind students, or when in the case of a company, employees, that connection to the internet or use of a website is a privilege, as demonstrated in the Loughborough University Janet Service AUP, and not a right. Through emphasising this privilege aspect, Northern Illinois University then make the connection that any abuse of that privilege can result in legal action from the university. In a handbook for writing AUP documents, the Virginia Department of Education indicate that there are 3 other areas needing to be addressed in an AUP. A statement that the AUP is in compliance with the state and national telecommunication rules and regulations. A statement regarding the need to maintain personal safety and privacy while accessing the Internet. A statement regarding the need to comply with fair use laws and other copyright regulations while accessing the Internet. Through a courtesy reading of the AUP statements found by a Google search, the variation of the inclusion of these items in an AUP document is highly variable. However, those statements in a school or university